Awesome. Hello, everyone. Good morning. Looking like the last week of the worst of lockdown. So I hope everyone's going okay. And for those that are double vaxxed, it might be a bit more freedom, a bit more exciting next week. And importantly, I guess, thank you for logging in for episode 1 of our SOPtoberfest again. We ran it for the first time last year, and I guess the purpose being to try and get everyone a bit up to speed on what's happening with payment, with the security payment legislation, particularly in New South Wales, and to treat it as a bit of an education session on going back to the 101 and basics around security of payment. So today is, the very first step, making a payment claim, and I'm here with Josh Mills, who's a legal project manager in our team. Morning, Josh.
Morning, Mike. How are you?
Yeah, good. So yeah, Josh is a UK admitted lawyer who's a project manager in our team and works on a lot of the security payment work with us. And yeah, I guess we'll dive right in. We think it's a pretty pertinent time to be talking about security of payment again. Just we've seen, I don't know if it's the tone or the vibe or the impact of lockdown or a state of where projects are in Australia with the rising cost of materials and all those kind of things. But we've certainly, for better and worse, seen a dramatic jump in security of payment activity compared to this time last year and the first half of last year. So lots of claims coming to life and being made. So we do think it's pretty critical wherever you sit in the industry to start to get across the 101 and basics again. I guess the context being, we're seeing claims from the people arguing about a couple of grand to probably some of the biggest claims we're seeing start to emerge are in those multi-million-dollar and $10 million range where there's big figures to be argued about, particularly on some of those mega projects that are coming to life in Sydney or off the the government spend. So I guess we get going, Josh.
Sounds good.
I'll let you be the slide master. So yeah, I guess some of the key things we're going to look at today are things around the timing, what form the payment claim takes, and the supporting documents. We're a bit further removed compared to last year from the most recent amendments to the New South Wales Act. We're almost 2 years past the latest round of changes, which, given how frequently the legislation has been changed, feels like a good chunk of time. It probably, we might be looking down some other changes in the near future that don't let us go too long without things being shifted. But for the purpose of today, we're looking at the Act post the 21st of October 2019. So there is some nuances and differences between the Act pre that date and the Act currently in effect. I mean, even as recently as this week, we've been looking at a contract that was executed. There's an argument about which side of that date it sits on. So just really put in context, this what we're talking about today is the Act as it applies to contracts entered into after the 21st of October 2019. So Josh, I'm going to throw to you to make a start.
Thanks, Mike. So just to start with, I'm just going to run through a couple of the questions we've got here on the slides, which will relate to who's entitled to a progress payment. So just to start it off, who is entitled to progress payment? A person who under a construction contract has undertaken to carry out construction work or to supply related goods and services is entitled to receive a progress payment. So it's pretty straightforward, and we'll touch on a couple of the exclusions which apply, but it basically covers the majority of the construction sector. So what is a construction contract? Construction contract is a contract under which one party undertakes to carry out construction work or to supply related goods and services for another party. It doesn't matter whether the contract is written or oral. So even if you don't have the physical contract, the security of payment process may still apply. And then for these last two, what is construction work and what are related goods and services? They're both pretty broad definitions. And if I click on the links here, you can see it covers sort of a range of different activities. Some of the types of claims that we've been seeing range from things like architects claiming for their design services, Some of those big infrastructure projects that Mike talked about earlier that are sort of in, the tens of millions of dollars, and that includes, the engineers on the projects and other similar sort of consultants, suppliers on residential and commercial builds, and builders of all shapes and sizes, really. You better see here in the definition of construction work includes alterations and repairs, restorations. So it doesn't just apply to new builds, it's all types of construction work. And it even goes in to include things like cleaning and painting and those things which happen at the end of a project. And equally things like site clearance and just those, and laying of foundations and general sort of maintenance at the start of a project too. And then just briefly touching on goods and services, obviously any materials or plant which is supplied to the project, and also labour and things of that sort of nature too. So it really does cover quite a lot of the activity undertaken in the construction industry.
Yeah, and I think going back to what you're talking about earlier, Josh, even the definition of what is a contract for the purposes of security of payment legislation is pretty broad, and the courts have usually looked at a contract or some other kind of arrangement. So, our experience includes erring on the side of caution for the large part, because if it looks or smells like there might be a contract there for the purpose of this legislation, our inclination is to at least consider that may be the case. And it's really important, just as Josh has emphasised, to understand just the breadth of what is covered by this legislation. So, no other industry really has something like the security of payment legislation over the top, where you've got a really powerful piece of legislation that's working to try and secure progress payments rolling through the industry. So we'll talk about this a bit more in the coming weeks, but the reason there's so much breadth around it was when the legislation first came in 22 years ago now, the idea is very much about protecting the mums and dads in the industry, making sure that there was a piece of legislation that would facilitate cash flow across the industry, and the breadth of what a construction contract is, as well as the breadth of construction work and related goods and services, is really important to consider that. So Josh will touch on the exclusions in a second, but the ones that aren't mentioned, like most of the stuff you're doing on these projects will be covered by that legislation. Legal work isn't, so we sit outside of it, and there is some arguments around, at least in New South Wales in particular, whether certain project management works are included in related goods and services. But for the large part, if you look at the breadth of what's even listed in construction work and in related goods and services, there's a good chance that if you're involved in the industry, what you're doing will be covered by this legislation. Thanks, Josh.
Cool. So just going to talk quickly about a couple of the exclusions. We are seeing with the amendments which come into the Act over time, they are becoming less and less because it is such an effective method of securing payment. So the current exclusions under the Act, the first one is that it excludes any work which isn't carried out inside New South Wales. So there are other security of payment regimes and legislation that applies to the other states and territories, but they do differ slightly, especially in terms of timeframes for payments and other sort of technical requirements. So if you are performing works outside of New South Wales, we highly recommend that you contact your legal provider and just get a little bit of advice on what it is you need to do before you make that first payment claim.
And I think it's worth considering, sorry, Josh, it's really worth considering, particularly when you're ordering materials. A good example is prefab concrete. If that's getting built on a site that's in Victoria, or manufactured on a site in Victoria, Queensland, ACT, similar, you need to work out if that work is going to fall under the Act. So if it's construction work that's carried out in that other jurisdiction, then arguably New South Wales legislation doesn't apply. We'll talk about what that means from a payment schedule perspective later on, but certainly if you're doing that work and you might have a plant or a site that's outside of New South Wales, it may very well be that work or that manufacturing piece around producing materials or the services associated with that might sit under a different piece of legislation. So just important to keep that context there.
Yeah. So just a couple of the express exclusions which are included in the Act. Drilling and extraction of oil and natural gas is excluded, so the security of payment legislation doesn't apply there. And also the extraction of minerals, so mining essentially. So any sort of tunnelling or boring or construction underground works, those kind of things will be excluded. But Mike, you've seen some examples where certain works on mining sites have been incorporated?
Yeah, absolutely. So I think I live in Newcastle. We're a coal mining town. We've encountered this argument more than once. You're taking stuff out of the ground. You're getting the minerals out. It's not covered. If you're building, for example, a facility or doing construction works on a mining site, there's a good chance that's covered. So you look at that on a case-by-case basis. But if you're actually building something for that mine site, then there's a good chance that the security of payment legislation would still apply. So if you're building a facility, some other things that might be necessary for the mine site that aren't just the boring or tunneling for the purpose of the mine, there's a good chance that that's covered by the security of payment legislation.
So one of the most recent changes, which has come in, and it came in on the 1st of March this year, are changes which affect owner-occupier construction contracts. So these are contracts for building work where, on a residential property, where the person who engages the builder plans to reside in those premises. So a good example that we had earlier this year was we had an owner who built 2 properties. One was a residential property where he was going to live, and the other one was a rental property. The contract was entered into before the 1st of March. So the old rules applied, and basically what this meant was that the builder was able to make a payment claim in respect of the work carried out on the residential property, but he wasn't able to make a claim for the work that was carried out for the rental property. Obviously, now since these changes are coming, for all
other way around, Josh. Yeah,
it
was. Yeah.
No, sorry. This predated the 1st of March.
Yeah, okay.
So now, obviously, if you had the same situation now post March, you'd be able to make a claim for both the residential property and the rental property. Yeah.
So it's a pretty dramatic change. It's the first time, it's the first time around, and for a lot of home builders that we've dealt with over the years, the process, if they don't get paid, has been you have the argument under the contract that may go nowhere, and the next step, and it makes most builders that have been through this process shudder, is trotting off to the New South Wales Civil and Administrative Tribunal to make a claim for payment. And we haven't done really the 101 of what the security of payment legislation is for the purpose of this this SOPtoberfest. We'll do a couple of short videos giving context, background, and dealing with some discrete facts or issues that arise under the legislation. But the context of the security of payment legislation is it generally does allow you to start the process seeking payment and get that amount paid within, it usually works out to be about 37 business days of the process starting. Now that might feel like a long amount of time. I can say for builders that I've seen, and particularly ones where they're in disputes with owners, some of them I've seen in NCAT for 2 to 3 years before they've got a decision, and then they're moving into a pretty protracted appeals process. The difference being, if you're dealing with something in a short, sharp and discreet way, not only do you get decisions quicker, it's also more cost effective. I can guarantee if you speak to anyone that's been involved in a 3-year litigation or any whether that's in NCAT or in the Supreme Court, it's pretty exhausting, both mentally, emotionally, and when it comes to the hip pocket as well.
Yeah, and just on the last point on that slide there, so for all owner-occupier construction contracts which are worth over $20,000, you've got to now include the Fair Trading Security of Payment Guide with the contract. And when we circulate these slides, we'll be able to send over links to all those resources that Fair Trading have provided. Yeah.
We'll also do, like as I mentioned, we'll have a couple of discrete ones around these pieces as well, so people can sort of log in and get examples around that. If there's any questions as we shoot through this too, please sing out. Obviously today's focus around payment claims, and if there's anything around that, but anything else, just throw it out as you come along it. Awesome. So Josh, did you want to run through the timing? I guess when claims are issued is one of those critical things that we have to look at more often than not.
Yeah, sure. So claims can be issued on and from the last day of the month in which the work was carried out, or if there's an earlier date in the construction contract, then it can be the earlier date too. You can only issue one payment claim per month unless the contract says otherwise. So one of the sort of common pitfalls we see is where a contractor might issue a payment claim for the contracted scope of works, and then they might issue a second claim for all the variations. And when you issue multiple payment claims, effectively they're all invalid except for the first one. Obviously, there's different rules. If the contract is terminated, the claim can be served on and from that date of termination.
Awesome. Yeah, so as Josh sort of highlighted, you've got to get it one per month or in accordance to the period allowed under the contract. If I'm being frank, it's very rare that we see a contract that allows more than one claim per month. Occasionally we see that in fit-out contracts or ones where there's sort of high, fast volumes of works. But for the large part, yeah, you're looking at that one per month. And it's really important that, you know, if you put a claim on, that you get all the information in that one claim. You've got all the amounts that you want to claim. We'll start to talk through that in a bit more detail from here.
Cool.
So, yep, sorry, Josh, you run through this.
No problem. So these are just some of the basics that you need to include in your payment claim. And most of them just relate to good administrative practice, really, more than anything. So the first one is obviously just getting the correct entity under the contract. So the company name and the ACN. If you've got multiple entities for the different types of work you take out, or if you're working for a company which has got lots of different subsidiaries, it's just to make sure you check the contract and make sure that the company names and the ACNs or the ABNs are correct.
Yeah. The easiest way around this is, like Josh has already said, it's around good contract admin, and the best way to make your life easy is right at the very front end. So when you first enter into the contract, doing that due diligence to make sure you've got the company name and the ACN right, particularly if you're dealing with a trade in trust or something like that, that you've got the correct entity and their details all correctly listed. And once you've got that right, assuming you take that information and run with it, it makes your claim that much easier.
So the next point just relates to identifying the work or the goods and services to which a progress payment relates, and also providing the supporting documentation. We talk about this a little bit more on the next slide, so I won't go into too much depth, but it's just, you know, important to include that you substantiate in all those claims for all the work that you've completed. Do you want to touch on that, Mike?
Yeah, look, the amount that claimed, I know that sounds like a silly one, but the amount of payment claims we see, and you know, we're fairly used to reading lots of different payment claims from lots of different businesses. The amount of claims we still see, though, where it is difficult, if not impossible, to determine what the full amount being claimed is unsettlingly high. And we raise that because, one, it's really difficult if there's a dispute brewing and we can't work out what's actually being claimed, both in terms of identification of the work and the amount. But two, if we can't work it out, there's a good chance the party that you're making the claim against can't work it out either, and that, one, is a recipe for dispute, and two, you know, means that things aren't getting communicated effectively on the project. So examples of what I mean when I say it doesn't indicate the amount of the progress claim. You know, is the figure inclusive or exclusive of GST? I love to see it big at the bottom, in big bold numbers at the bottom of the page, and inclusive of GST amount that identifies clearly what the full amount is being claimed. If people are claiming, you know, progress works, you know, potentially some variations, but, you know, maybe we've got some suspension costs as well thrown in. If there's a whole bunch of things and it's not all collated and added up to be one figure, it can be confusing as well. So, or you've got a spreadsheet that's just got lots of little items, but there's no total in it. Again, it comes down to good contract administration. But if you're able to put all those things together and put it in a way where it's clear what that figure is, that's, you know, one, that's essential for making a valid claim, but two, it's, you know, it goes a long way to actually getting paid without having to use this legislation.
Yeah. So one of the sort of most important things in this slide is that you must state that it's a payment claim made under the Act. They call these the magic words. There's something which sort of seem to drop in and drop out of the different versions of legislation, but I think in 2019 it came back in, so now you must include it put it on the first page of your payment claim, put it nice and bold and visible, that just states that this is a payment claim made under the security payment legislation.
Yeah, great. And then obviously there's the supporting statement as well. We'll touch on this today, but we'll also upload a short little video explaining how supporting statements work in a bit more detail, because we do get a few questions around that, and we'll try and get a fact sheet up around supporting statements as well.
Cool.
Yeah, so it's really, it is really critical here to get the right information and details into your payment claim to identify and detail the work. That varies a fair bit from project to project, doesn't it, Josh? I mean, if you're working for one person doing a concrete pour and it's got the words concrete pour on there, that might be reasonably identifiable. If you're working on the next stage of WestConnex and there's multiple moving pieces, the shape and form and the information that claim is going to look very, very different.
Yes, right. And it's just important that you include all the information that supports your claim in that payment claim. So the case at the bottom there, John Holland versus Cardno, what happened in that case was that John Holland engaged Cardno as a consultant on for civil works on the Parramatta Rail Link project. Cardno made a payment claim for $1.2 million, and John Holland disputed this amount in the payment schedule. That subsequently went to adjudication. And when they were including their submissions, Cardno included a bunch of new contractual basis and supporting documents, so things like timesheets and just other information which they hadn't included in the payment claim. So John Holland argued that this was a denial of natural justice because they hadn't had a chance to respond to this new information when they submitted their payment schedule. And the court ultimately decided in their favour, and they set aside the adjudication. So the moral of the story is that you can't include additional contractual basis or supporting documents which you don't include in your payment claim. So it's really important that you include all that information to support your claim in the payment claim.
Yeah, and I think you've got to put the context of what the legislation's for around that. I speak to people occasionally like, oh, what do you mean? We want to have our smoking gun, or we want to ambush them, and that's not the purpose of the legislation. Like, this is a fast-track dispute resolution process, and it's been built and designed to try and get cash flow rolling through the industry. And the best way to do that is to not go through an adjudication process. It's to have a payment claim serve a purpose of putting someone in the best position to be paid. And to be in the best position to be paid is to have the party you're seeking payment from understand what that claim is. It's not particularly helpful to either party if you suddenly thrust a whole bunch of information that you could have put out earlier upon them during an adjudication process. So we talk about it. My colleague Belinda and I have spoken about it with some industry bodies in the past. Like, treat the documents you're producing both under the contract and particularly under the security payment legislation as communication tools. They're swords and they're shields and whatever else you want to call them, but they're also really effective documents in communicating what you're seeking and why you're seeking it. And if you've got that detailed, comprehensive, clear, well articulated and organised information attached to your claim, one, it puts you in the best position should a dispute arise, but two, it probably puts you in the best position to avoid the dispute altogether. I know most of the people are on here today because they don't want to be dealing with lawyers at 10 paces, and one of the best ways to do that is to have a good, clear, comprehensive claim. And look, Josh, you've looked at it both here and in the UK, and I think that rule runs true across jurisdictions, doesn't it?
Yeah, absolutely.
Right. So jumping forward, so look, I mean, I'm not going to talk through all the case law here. I think the case Josh runs through is a really good example, but identify the goods, identify the works, identify the services, put it in a way that they can understand it, put it in a way where if they do dispute it, they can give you the proper reasons in a payment schedule. Again, let's go back to that clear communication. If they can understand what your claim is, even if they disagree with you, it puts them in the best position to put a reasoned response back, and we'll cover that in our next webinar, which will be around payment schedules and what that means if you're responding to a claim. And the court's not going to take a unduly strict approach to the construction of the claim. They're going to look at it in a common sense approach. They're going to look at the practicalities of how you've dealt with it in the project. Like I said, someone building a house and then someone claiming for a concrete pour, putting down concrete pour makes sense. If you're doing a claim on WestConnex, it looks very different. And you need that information to be clearly digestible, clear and digestible. Just dumping 20,000 documents on the back of a confusing claim does not help anyone. And in our experience, the courts aren't too fond of that process in terms of that lazy claim preparation. So it can be short, it can be succinct, but there should be supporting material and it should be very clear and digestible and understanding. People should understand what you're claiming and why and how.
Yeah, so, I mean, some of the best ones I've seen here and in the UK tend to just have like a summary page on the front. You have the magic words in there, you have all the details, and you just have a succinct breakdown of what it is that's being claimed. And then you can annex all those timesheets or those Excel spreadsheets or wherever it is, which takes up, additional space on the next sort of couple of pages. Yeah,
right. Thanks, Josh. Again, if any questions are coming up, people, as we run through this, please let us know. We're trying to keep it short and sharp because I know a lot of people are Zoomed and Teams and webinar'd out, but so we do appreciate you being here, but sing out if you need anything. Covered it briefly already. The courts have looked at it and said if you can't explain the sums, if you can't, if the dollars don't make sense, then it's not going to get you across the line. The figure should be clear. It should be easy for the person responding to the claim to understand. It should be easy for us as your lawyers to understand. It should be easy for an adjudicator, if it goes to dispute, to understand. You need to put out those figures in a clear and digestible way. Good contract admin, as Josh has already said, goes a long way, and that means having a structured approach to how you do all these elements. So other things that can be claimed in addition to the works, if you have a right under contract to suspend, and that contractual right also gives you an entitlement to claim for delay cost. Delay costs are claimable under SOP if it is permissible under your contract. There is no entitlement to claim general damages. So if it's not dealt with, if it's just left open-ended, you're not going to deal with that under SOP. But if there's a genuine right to claim delay costs and a mechanism to deal with that under your contract, those are claimable through security of payment. You can also use security of payment to recover security and retention that is due for release. Just two other things to keep in mind when you're using your payment claim about beyond the works. You can look at those things as well.
We've already touched on this briefly about these magic words, but it is so important. Just thought we'd include it again. You've got to endorse your payment claim with these words. So you've got to state that this is a payment claim made under the Building and Construction Industry Security of Payment Act 1999. When we've seen some examples where you have otherwise a perfect payment claim, but they just omitted these words and the courts have found that it's invalid.
And they haven't made it easy. Like, we acknowledge that. We had the words, and then we've taken them away, and then suddenly we've thrust them back upon everyone again. And I know that in 2 years, not everyone's updated their template claims. This week, or in the last week, it was last weekend this week, in the last 7 days, I've seen 2 lots of claims from separate people where everything else was put together meticulously and was really well done, but they've omitted the magic words because the contracts were entered into after October 2019, and unfortunately their templates in the system hadn't been updated. So they don't have, despite there being a dispute brewing, they don't have the option to go into security of payment because it's not a valid payment claim because the magic words are missing. If you take one thing out of today, it may very well be just going back and checking what your template looks like in the system. And my view is it doesn't. If you do have any contracts on foot that predate the 21st of October 2019 changes, it doesn't invalidate it to have those words at the bottom of those anyway. So, my approach has generally been, I'd prefer the template to have those words rather than having an active step to get on there, because we've seen people miss it more often than not. And unfortunately, the moments they've missed it is when there's a critical claim or a critical dispute arising.
Great.
So service, Josh, this is one of the fun parts.
Yeah, that's right. So once you've prepared your claim, obviously it needs to be served. The contract gives a number of different ways that this can be done. The first step is obviously just to check your contract and check exactly which the preferred method of service is. But irrespective of what it says, you can still serve a valid payment claim by personal delivery to the respondent. And that can include lodging the claim at their place of business during, the standard office hours, by sending the claim by post to the address of the business, and sort of more recently, email to the relevant person. But it's important that the email address is specified, usually in the contract, as the specific place for progress claims. So we've seen people get stuck here a couple of times, Michael, haven't we?
Yeah, and I think, let's just adopt good practice. I know not everyone does, but there's no point trying to be, sly or clever about it. We've had scenarios, and the courts look pretty unfondy on this. And people do get their responses on in time. The adjudicators generally look pretty unfondly on this as well. But I've had a client where the project's been undertaken in Sydney, and someone's tried to be clever and serve a payment claim on one of their unmanned offices in regional New South Wales because they knew the project manager there was on leave. There's no point trying to be difficult about it. I know when you're dealing with particularly tier 1, tier 2 contractors, there's lots of places that you might be able to deliver the payments claim to, but it should be to the relevant and normal place of business for that, particularly for that project. There's been some decisions in the last 12 months where the courts just said, look, you deliver it to a random person at a random office is not sufficient service. They sort of cut through the bullshit around that. And same as if you send it to an email address that would have no idea, within that business would have no idea what you're talking about to try and sort of get one through the keeper. There's a pretty reluctant approach from the court to say, well, that counts. So like Josh said, get the email address, serve it on the email address specified in the contract. And if that's not specified, it should be an email address to someone that's clearly identifiable as engaged and relevant to the project.
Yeah, it's a really important step because this kickstarts the whole process really. And if you sort of go through all that work, prepare an adjudication and things like that, then you've got to make sure that it was definitely received. You've got to have a good case that the payment claim was served, in accordance with the contract or the Act. Yeah,
and emails are great. You can show receipt, and the Act allows it. I mean, if you deliver it to their office or if you post it to their office and it's a critical claim, express post can be great because you can track it. If you deliver it to the office, record the details. It's useful to say, hey, if I was delivering something, I'd say, look, I popped into the Morrissey Law office. It was just after 11:30. I handed it to Josh, who was wearing a light blue t-shirt. You can do a quick note either in your phone or in your diary or on an email to someone else in your business saying, "Yep, payment claim dropped off. Here's the details." Like, particularly if you think it's going to be a contentious one, like it's not that hard to record that information. I mean, we've got smartphones there. Take a photo out the front of their address as you're there, so you can sort of show you were there. There's a lot of different ways you can evidence it. And the amount of times over the last 13 years that I've had to deal with disputes around was it or wasn't it served, that were where those disputes were curable by just a little bit of basic data, a little bit of record keeping, would have made everyone's lives a lot easier and cheaper. We're not going to run through all the cases. They kind of reflect what we're saying. The legislation now gives some pretty strict dates around payment that you have to work in if your construction project is covered by it, Josh.
Yeah, so if you're a head contractor working on a main contract and you're making a payment claim against a principal, generally you have 15 business days from the date of the payment claim, unless there's a shorter period stated in the contract. It changes slightly if you're a subcontractor. If you're working on a non-residential build, and it's 20 business days from the payment claim. And it's even short again if you're a subcontractor working on a residential build, it's 10 business days. The Act provides sort of maximum time limits, so the due date for payment can't be later than these times. So it's the earlier of the contract or the Act.
Yeah, you can't contract out of it. I mean, in the last 12 months, I remember having a chat with our friends at the Civil Contractors Federation around after the bushfire, after all the bushfires and the amount of construction work that had to be done in response to that, and government was trying to say, "Oh, look, we don't have to do it in the 15 business days," and you know what they did. No one gets to get out of it. It's if your financier says I can't pay that within 15 business days, it's a bit of suck it up. That's what's required. And in my view, most financiers now, particularly when you're negotiating with the owner, and they said, "Oh, we can't do 15." It's just, well, too bad. That's what it is. That's what's happening on all these projects. Whether they're multi-billion dollars or they're worth a few $1,000s.
Yeah, one of the questions we get a lot of the time as well while we're talking about the due date for payment is whether interest accrues on unpaid amounts after the due date. And the answer is just straightforward, yes. If there's an interest amount stated in the contract, then that's what applies. Or otherwise, Section 101 of the Civil Procedure Act prescribes the rate, which is 6.1% at the moment. That changes every sort of 6 months. It's the greater of those two.
Yeah, great. And it's a matter as to whether you want to claim that interest, but it's there, and it's a very real thing. Thanks, Josh. So I guess, that kind of takes us to the 101 of payment claims. I mean, the critical things are look at your contract, work out what you need to get that claim on, and look at those critical things, get the parties right, identify the project, identify the works, make it clear what the works are and what the amounts being claimed are, get the magic words on there and get it served properly. Those essential items, if you need to use this legislation, and hopefully you don't, but we are seeing people increasingly have to use it. You need to make sure things are right, because it's pretty painful if you don't get it quite right and you have to roll it over to the next month to try and use this. And like I said, we're going to, as part of this year, we're going to do a number of little short videos that we'll upload. I'll do one around what the purpose of the Act is and what its power is. We'll do Josh. I think Josh is touching on supporting statements. I think Pat, one of our other lawyers, is touching on the context around the residential system. Kerry has asked a question. Sorry, so we've got our first question. Thanks, Kerry. A lot of our clients have their own versions of StatDex. Is there an industry standard of StatDex that needs to be submitted with the claim? If you're required to put in a supporting statement, so the Act requires a supporting statement if you're a head contractor. Now, the form of that supporting statement is provided, and you can obtain it through the Fair Trading website. We'll share some fact sheets around this over the course of the month, including links to those relevant documents. That doesn't mean that under your contract, your clients might not have their own versions of the documents that need to be attached, and that can include their own versions of StatDex and other things. My advice around that is, when you're negotiating the contract, make sure those documents are in a form that you can provide. I've seen some very unusual and very onerous StatDex popping up, particularly on major infrastructure projects in the last 12 months. Under the legislation, you don't have to provide that, but if you go to adjudication or to the courts, they often do look at, well, what were you required to provide under the contract, and they make an assessment as to whether that should have impacted on your entitlement. I hope that answers the question for you, Kerry. But yes, in terms of supporting statements, there is a strict version in terms of the StatDex that clients require from time to time. That's a bit more open-ended. Any other questions, please let us know. But like I said, we'll start to upload a few other just short videos, just sort of giving updates and facts, and we'll make sure that that's made available to you. If we jump onto the last slide, Josh, next week is payment schedules, and looking at the people that are here today, the names that I recognise, hi to most of you, the ones that I don't recognise, hello for the first time. But payment, if you dispute a claim, you have to get a payment schedule on, and yeah, we say this all the time. I'm lecturing at Newcastle Uni on Friday, and I'll be saying it there as well. Payment schedules, if you're disputing a claim, are the most critical document in this whole security of payment process. So, it's going to be a really important one next week, which is covered by one of our directors, Hamish Geddes, with a senior associate in our team, Marianne Wen. But look, thanks everyone for coming along. Thanks, Josh, for preparing this. Any other questions, you've got our details and our firm's details. Please just reach out and let us know if there's anything else you'd like us to cover during SOPtoberfest, and hopefully that can help. And if any claims pop up, we're here to help as well. Thank you.
Thanks, guys.